Almighty God, by whom alone kings reign and princes decree justice, and from whom alone cometh all counsel, wisdom, and understanding. We, thine unworthy servants, here gathered together in thy name, do most humbly beseech thee to send down thy heavenly wisdom from above, to direct and guide us in all our consultations. And grant that we have in thy fear always before our eyes, and laying aside all private interests, prejudices, and partial affections, the result of all our counsels may be to the glory of thy blessed name, the maintenance and true religion of justice, the safety, honor, and happiness of the King, public will, peace, and tranquility of St. Lucia, and the uniting and knitting together of the hearts of all persons and estates within the same, in true Christian love and charity, one towards another, through Jesus Christ our Lord. Amen. The grace of our Lord Jesus Christ, and the love of God, and the fellowship of the Holy Ghost be with us all evermore. Amen.
Good afternoon, members. And I want to apologize for the late start, but also to thank members for their cooperation. I have been advised of the absence of the member for Ancillary Canneries and the member for Labrie. The member for Vieux-Fort South is expected to join us as soon as he's able to. Statement by ministers. Papers to be laid. Minister for Finance.
Mr. Speaker, I beg to lay the following paper standing in my name, signed instrument number 104, 2025, Customs Duties Amendment of Schedule 4, number 1 order.
Deputy Prime Minister.
Mr. Speaker, I wish to table the following paper standing in my name. Statutory Instrument number 105 of 2025, Tourism Development, Majestic Beach Chair Rentals and Grill Order.
Bills. Minister for Finance.
I beg to move for second reading a bill shortly entitled Payment System and Services. Mr. Speaker, this bill is a creature of the Eastern Caribbean Central Bank, and it aims at harmonizing the processes and the procedures of payment systems and services providers in the region. Mr. Speaker, the purpose of the Payment System and Services Bill is to provide for the licensing and regulation of payment service providers and the oversight of the payment system. Mr. Speaker, payment service providers means people like Shopee and Penny Pinch and these kinds of organizations. Presently, the advancement of the operation and regulation of the payment system generally and particularly is provided for under the Payment System Act, Cap 12.24, the Act. Additionally, the Act codifies the procedures governing the payment system. The Eastern Caribbean Central Bank, for the Eastern Caribbean Central Bank Agreement, has the power to regulate and have general oversight of payment and settlement systems, purchase payment facilities, and netting contracts or arrangements. Under the Act, the Central Bank has exclusive authority for the supervision of the payment system as indicated. Mr. Speaker, the payment services landscape has changed dramatically, and the Central Bank, interested in nurturing a payment system environment that attracts innovative payment services, from non-bank service providers in the interest of financial inclusion and the reduction in the use of cash, drafted this bill with the assistance of regional legislative drafting consultants. In addition, the bill is an integral component of the Central Bank's Modernization and Development Plan for the payment system in the Eastern Caribbean Currency Union, ECCU. It is also part of the Caribbean Digital Transformation Project in the Eastern Caribbean, spearheaded by the World Bank in collaboration with the organization Eastern Caribbean States Commission. Between 2021 and 2024, the bill, through several consultations, was reviewed by Attorney Generals and Parliamentary Council in the Eastern Caribbean Currency Union. In June 2024, the bill was recalled by the Central Bank to make provisions for the inclusion of the Office of Financial Conduct and Inclusion, OFCI. However, the Central Bank made the decision that the bill is enacted with the understanding that the amendments to make provisions for the OFCI will be undertaken following its enactment. The bill had its first reading in the House of Assembly on 10 December 2024 and in the Senate on 12 December 2024. As a result of the bill not being presented for second reading during that session of Parliament, the bill had to be reconsidered by Cabinet for transmission to Parliament for enactment in the new Parliament system. The objectives of the bill, Mr. Speaker, are to introduce a comprehensive licensing regime calibrated to specific tasks, to specific risks posed by the activities through a new modular approach to regulation that facilitates growth in innovation and financial inclusion. Broaden the scope of regulated activities to non-banks to accommodate a wider range of payment services and activities. Strengthen consumer protection. Engender confidence in the use of electronic payments and enhance safety and efficiency in the Eastern Caribbean Currency Union payment system and the capacity to maintain financial stability. The bill makes provision for its purpose under Clause 3 of the bill, which is to establish a legal framework to enable a payment system that is safe, efficient, resilient, inclusive, and competitive for the management of risk, the maintenance of financial stability, and the protection of the interests of consumers. Part 1 of the bill contains the administrative provisions. Therefore, the functions and powers of the Central Bank are set out in Clause 4 to 8 of the bill. Generally, the Central Bank is empowered to monitor and oversee the payment system, promote financial inclusion and financial innovation, protect consumers and ancillary to these powers, continually modernize the payment system through new policies, establishing standards and procedures, and monitor and oversee the clearing and settlement system. Additionally, the bill empowers the Central Bank to support the operations and participants of a payment system, including ownership and participation. The Central Bank is also empowered under the bill to establish, own, operate, or participate in the ownership of a system, act as a central counterparty, open and hold accounts for an operator or participant, and hold securities for clearing and settlement of transfers, and direct the payment system provider to enter into an arrangement with the operator of the payment system to achieve interoperability of the payment account with the payment system. In carrying out these functions and powers, the Central Bank, in accordance with the bill, will cooperate with other public authorities engaged in regulation and supervision of financial institutions and other entities directly or indirectly involved in payment services and their operations. In the bill, the Eastern Caribbean Payments Council is established under Clause 9 of the bill for the purpose of advising the Central Bank on the oversight of the payment system. In addition, the bill makes provision for the composition, appointment of a chairperson, and gives the Central Bank the authority to make rules relevant to the operations and functions of the Eastern Caribbean Payment Council under Clauses 10, 11, and 12 of the bill. Mr. Speaker, under Part 1 of the bill, a license may be issued to a person who operates a system or provides a payment service without a license to do so from the central bank under clause 13 of the bill. A penalty is created under the bill if a person does not obtain a license in accordance with the bill. Classes of licensing may be created by the central bank after consultation with the Minister of Finance under clause 14 of the bill. The procedure for obtaining a license is provided for in clauses 15 and 16 of the bill. Once issued, a license is not transferable according to clause 18 of the bill, and conditions may be imposed on the licensee, including the conditions in relating to the electronic money order clauses number 19 and 20 of the bill. With respect to the license, the bill provides for the duration of the license under clause 21 of the bill, renewal of the license and suspension or revocation of the license under clause 23 of the bill. The minister, on the recommendation of the central bank, is empowered to prescribe fees which include a non-refundable application fee, license fee, and an annual fee under clause 24 of the bill. Obligations of the licensee. Licensed financial institutions or credit unions are set out in clauses 25 and 26 of the bill. Therefore, the license must be displayed of the bill, and in the case of a licensed financial institution or credit union, notice must be given to the central bank in relation to criminal proceedings, insolvency, disciplinary action, and material changes to products and services. The bill also makes provision for operational requirements for the central bank, licensed financial institutions, and credit unions under clause 27 of the bill. Provision is made in part 3 of the bill for the oversight under clauses 28 to 47 of the bill. According to the bill, the central bank may issue rules or directives to any payment system provider or operator, and at any time adopt general standards and criteria for the conduct of payment services or the operational systems. The bill empowers the central bank to monitor emerging and innovative payment systems and technologies, receive applications for the innovative payment system and technology to be reviewed, tested, and monitored, issue guidelines prescribing the mechanisms to review, test, and monitor an application for the provision of an innovative payment system or technology. A licensee and a participant are required under the bill to provide any information requested by the central bank in relation to its business or the business of its affiliates, make staff available for interviews with the central bank or any person appointed by the central bank when necessary. An offense is created for failure to comply, or if false or misleading information may be provided. The central bank, in accordance with the bill, may enter and search premises in the company of a police officer, conduct an audit, or commission an independent auditor to conduct an audit of an operator, participant, or payment service provider, and publish information under certain conditions. The bill imposes a duty of confidentiality on the central bank regarding any information or document obtained during the exercise of its functions under the bill, and sets out exceptions. Restrictions are placed on payment service providers in relation to the use of agents and licensees with respect to the outsourcing of activities and compliance with anti-money laundering and combating the financing of terrorism and proliferation of financing. Mr. Speaker, the central bank may designate a payment system under Part 4 of the bill, in accordance with clauses 38 to 34 to 40 of the bill, and must have regard to matters such as the number and value of the transactions that the system presently processes or is likely to process in the future, the safety, integrity, fairness, transparency, effectiveness, and efficiency of the payment system, and the number and type of participants. The bill also allows the central bank to revoke a designation. The bill makes provision for rules to regulate systems in Part 5 of the bill, under clauses 41 to 43 of the bill, by requiring an operator to establish clear written rules for the governance, management, operations of the system which the operator is licensed to operate, giving the central bank the ability to validate or invalidate the rules of the operator, and providing the central bank with the power to mandate that rules on access to payment, clearing, and settlement systems must not inhibit access to more than is necessary to safeguard against specific risks and to provide the financial operational stability of the system. In relation to consumer protection, the bill provides in Part 6, under clauses 44 to 47, that the central bank may establish rules to ensure transparency of conditions, including fees and information requirements for payment services, and the central bank is required to publish the rules on its website. The bill requires a licensee, a participant, or an agent provide a notice to the customer of a fee for executing a payment service and to disclose specific terms and conditions to a customer of a payment service involving the customer's account at the time the customer contracts for the payment service. The bill also provides for complaints of a customer to be made in the first instance to licensee, participant, or agent, and in the second instance to the central bank. Mr. Speaker, the bill also makes provision for settlement, netting, and finality in Part 7 of the bill, as well as winding up an administration of a systems operator, a participant, or payment system provider in Part 8 of the bill. Administrative matters and penalties to be used by the central bank are set out under Part 9 of the bill. Other provisions in Part 10 of the bill include the enforceability of electronic fund transfers, indemnity of central bank officials and other officials, making of rules, directives, and guidelines by the central bank, and making of regulations by the minister. Mr. Speaker, I've tried to summarize the payment system and services bill, Mr. Speaker, as you would have heard and you would have read, Mr. Speaker. That is basically a mechanism by which consumers are protected, and there's a clear process and procedure under which payment systems by third parties are processed for the consumer, Mr. Speaker. All leading, hopefully, for the consumer to benefit, for the system to be transparent, and for the consumer to be assured that when they go to these, when they access these services, their money goes to the right place and all the processes are correct, so that they can use these systems with confidence, because of the fact that there are certain regulations and laws that guide their processes. I thank you, Mr. Speaker.
Honourable members, the question is that the Payment System and Services Bill be read a second time. Member for Social Saltibus.
Thank you, Mr. Speaker. Mr. Speaker, I rise just to indicate solidarity with the passing of this bill, because definitely would be something that the consumer will benefit from. My only concern, Mr. Speaker, would be that there's a very systematic system in place to identify an early warning system to identify liquidity and any settlement risk involved. That would be my only major concern, and of course that the whole issue of confidentiality is one that is very rigorous, and that the powers that be have clear oversight over. So that being said, Mr. Speaker, I'm in full support of the bill before us. Thank you very much.
Do you wish any rebuttal, Minister for Finance?
Speaker, Member for Choiseul is correct, and I thank him for his observation and his support.
Honourable members, the question is that the Payment System and Services Bill be read a second time. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to provide for the licensing and regulation of payment service providers, the oversight of the payment system, and related matters.
Clause 2.
Interpretation.
Clause 2 stands part of the bill. Clause 3.
Purpose.
Clause 3 stands part of the bill. Part 1, clauses 4 to 12.
Administration.
Part 1, clauses 4 to 12 stands part of the bill. Part 2, clauses 13 to 27.
Licensing.
Part 2, clauses 13 to 27 stands part of the bill. Part 3, clauses 28 to 37.
Oversight.
Part 3, clauses 28 to 37 stands part of the bill. Part 4, clauses 38 to 40.
Designation of payment systems.
Part 4, clauses 38 to 40 stands part of the bill. Part 5, clauses 41 to 43.
Rules to regulate systems.
Part 5, clauses 41 to 43 stands part of the bill. Part 6, clauses 44 to 47.
Consumer protection.
Part 6, clauses 44 to 47 stands part of the bill. Part 7, clauses 48 to 52.
Settlement, netting, and finality of payment.
Part 7, clauses 48 to 52 stands part of the bill. Part 8, clauses 53 to 59.
Winding up and administration of an operator, a participant, or a payment service provider.
Part 8, clauses 53 to 59 stands part of the bill. Part 9, clauses 60 to 65.
Administrative measures and penalties.
Part 9, clauses 60 to 65 stands part of the bill. Part 10, clauses 66 to 72.
Miscellaneous.
Part 10, clauses 66 to 72 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of their opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honourable members, I beg to report that the Payment System and Services Bill went through committee stage without amendments. Minister of Finance.
I move that the report of the committee be adopted and the bill be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the Payment System and Services Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This Act may be cited as the Payment System and Services Act 2025.
Minister for Finance.
The Speaker, I beg to present for first reading a bill shortly entitled CARICOM Arrest Warrant Treaty.
CARICOM Arrest Warrant Treaty.
Mr. Speaker, I beg to move that this bill be presented for second reading at the next or subsequent sitting of this Honourable House.
Minister of Finance.
Mr. Speaker, I beg to present for first reading a bill shortly entitled Administration of Small Successions Amendment.
Administration of Small Succession Amendment.
Mr. Speaker, I beg to move for the suspension of Standing Order number 48-2 to enable this bill to go through its remaining stages at this sitting.
Honorable members, the question is that Standing Order 48-2 be suspended in order to allow the Minister of Finance to proceed with the remaining stages of this bill at this sitting. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it, the ayes have it. Leave is granted. Please proceed, Minister.
Thank you, Mr. Speaker. Thank you, honorable members. Mr. Speaker, this is a simple, Mr. Speaker, but significant piece of legislation. Really, thank you. It's a simple, Mr. Speaker, but significant amendment, Mr. Speaker, of the government's policy of putting people first, Mr. Speaker. And I'll tell you what, Mr. Speaker, this previously, Mr. Speaker, if someone died intestate, and the lawyers will tell you intestate means you die without making a will, and that person possessed property or vehicle or housing appliances, electronic equipment that he wanted to give to someone else that was the value of over $5,000 or more. They had to have letters of administration and go to the court and etc., Mr. Speaker. And many people could not afford it. They could not make the necessary arrangements with lawyers, etc., Mr. Speaker. And basically sometimes not wasted, but the court's time could be used for better purposes, Mr. Speaker, than to deal with $6,000, $7,000 worth of inheritance, Mr. Speaker. And it caused frustration, it caused a lot of ill will, Mr. Speaker, and sometimes even issues as it relates to families. Families not understanding that letters of administration have to be prepared, etc., Mr. Speaker. So, for simple things, not somebody for massive inheritance of land and buildings, etc., but for regular people who have inheritances of 20,000, etc., Mr. Speaker. So, Mr. Speaker, the Cabinet took a decision that they would amend the Administration of Small Successions Bill, Mr. Speaker, Administration of Small Successions Amendment Bill, Mr. Speaker, which allowed the transfer of property where the value of movable and movable property comprising the succession or intestate succession of a deceased person if it does not exceed $40,000 from $5,000. Before, Mr. Speaker, it had to be $5,000 or less. Now it's gone up to $40,000. So in that case, the registrar has the powers to prepare the letters of administration and the succession and allow the people who can inherit, allow them the power or make the processes possible for them to inherit what that person who died in intestate, what that person left, Mr. Speaker. Just because I said it's a very significant piece of legislation. A very significant legislation, Mr. Speaker. And the registrar of the High Court, Mr. Speaker, can now act similar to a magistrate. He or she will have the jurisdiction over an intestate succession of up to $40,000. And a person who desires to administer an intestate small succession can do so without incurring additional legal costs and fees, Mr. Speaker. And the Attorney General in the Cabinet was concerned about that part of the bill, Mr. Speaker. So, Mr. Speaker, I think that the public needs to be informed about that development because it's small but it's significant. It's very significant, Mr. Speaker. Mr. Speaker, just recently, somebody in my constituency passed away, and he was a small contractor. The government owed him $20,000, and his mother came to me telling me, could I give her a letter for him to... Mr. Speaker, when you're a politician, the kind of things people think you can do, it's really, 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 sometimes it's mind-boggling, the things people think you have the power to do. So the mother could not understand that I could not give her a letter to go to the bank to take the guy's $20,000. She says, I was the Prime Minister, as the Minister of Finance, I could do that. And of course, Mr. Speaker, you know, she would go to people who would tell her I can do that. That's how it is, especially now. So, Mr. Speaker, so that solves a lot of these problems. So the registrar will have the power to make all these things possible, Mr. Speaker. So I commend members to support the bill. I think there should be adequate public relations to the public to make them know that has happened, because I'm sure it will make many people happy. So my constituent whose son has a $20,000, once the registrar agrees and everything is in order, Mr. Speaker, she'll be able to get her $20,000, for which she'll be very thankful. So, Mr. Speaker, I think it's a simple, significant, and appropriate amendment to the small successions amendment bill, which I urge honourable members to support. I thank you, Mr. Speaker.
Honourable members, the question is that the Administration of Small Successions Amendment Bill be read a second time. Member for Castries Southeast.
Thank you very much, Mr. Speaker. Mr. Speaker, I rise to support the Administration of Small Succession Amendment Bill. Mr. Speaker, the Minister of Finance, the Prime Minister, has indicated that it's a very small bill, but significant. But, Mr. Speaker, in my own humble opinion of what has transpired or what is happening here, this is really significant for the people that I represent as far as the work of the Ministry of Equity is concerned. Mr. Speaker, I think it is in Proverbs 13, verse 22, it says, a good man leaves an inheritance to his children's children. And Mr. Speaker, over the years, one of the greatest challenge for a number of families, especially mothers, parents, they live their entire life thinking as to what do they leave behind for the children. And poor families would reconcile during their life that they can't leave anything behind, so they focus on their burial. They join the society group. And for a lot of families, a lot of parents, they ensure that they leave behind something that their children can take responsibility for their burial, because they cannot afford to leave behind some of the other things that people leave behind for their families. Mr. Speaker, when we speak of wealth creation, a significant part of wealth is based on inheritance. And those of us who research some of the economic magazines, we would see this in a year, what is the total amount of inheritance that goes through the American system, and the amount of taxes that is collected from the government in terms of inheritance. Mr. Speaker, that challenge by the average family or persons who are challenged, they reflect on the issue of poverty. And of course, Mr. Speaker, they would pay attention to how they live their lives. But of course, the experts, Mr. Speaker, the experts would have also considered that, and they have developed the multiple index, poverty index, capturing 3 areas, Mr. Speaker, 3 pillars. And those 3 pillars are captured in health, education, and the standard of living. Mr. Speaker, the last time I spoke here, I mentioned that health captures, nutrition and child mortality, education. They speak of years of schooling and school attendance. But the standard of living is where I would like to focus on, because it speaks to cooking fuel, sanitation, drinking water, electricity, housing, and assets. Mr. Speaker, the multiple index of poverty consider assets as a very important indicator. But what I found interesting in terms of the discussion among professionals, they focus on assets relating to a television in a poor man's home, a refrigerator, some sorts of household items. But Mr. Speaker, the issue of assets goes deeper than just these mere household items. And therefore, Mr. Speaker, the legislation, the amendments being made to allow someone to go to the registry to inherit through the registry a property value $40,000 is very, very significant. Mr. Speaker, in my professional work as a quantity surveyor, there was, in recent time, 1 carry or 3.2 acres of land was being valued at about $50,000. A farmer somewhere in Tetshime Millet with 3 acres of land or 1 carry of land and the banana and it's taken up with black sikatoka can be sold on the market or valued at about $40,000 sometimes or less. It means therefore that the children would have difficulty inheriting that piece of property, and therefore a lawyer, they would have to go to a lawyer, and then of course they have to pay fees to the lawyer, and that challenge would prevent the family from having that inheritance. What the government has done is to make it possible that if you have an acre of land in Tetshime Millet, that a family member can go down to the land registrar with the death certificate, birth certificate, and have letters of administration prepared so that they can inherit the property. Mr. Speaker, this is significant. This is important, Mr. Speaker. Mr. Speaker, and of course, I would want to even be a little more innovative if I was part of a family where there are 10 acres of land and there are 10 children. It means that the property can now be subdivided in 1 acre each, and each person can go down to the land registrar and now have their own letters of administration for their 1 acre parcel. It is now possible through this piece of legislation that 10 acres of land can now be inherited through the land registry with a subdivision plan, with each child going and inheriting their acre of land. Mr. Speaker, I really want to commend the Prime Minister on this initiative. I did speak with the Attorney General on this matter quite a bit, because I said to him, the lawyers will stop making so much money on succession deeds. I've said that the issue of poverty and it is very systemic, because it's difficult for some persons to inherit or to grow, to develop wealth through inheritance based on the amount of hurdles, the cost of getting lawyers and all of these sort of things. So certainly, Mr. Speaker, anyone who would reflect on the amendments being made from $5,000 to $40,000 would recognize this is significant in having the registrar to process, whether it is through letters of administration or whether it is will or what have you, so that persons can inherit property. And I think, like I've said in most of my presentations to parents, I have said that it is okay for you to leave something behind for your kids. And this sort of idea would encourage parents to not to feel troubled that if you have $8,000 in the bank, it would not be difficult for your children to inherit it, and they would not have to pay a lawyer half of it to inherit it. You could now go to the land registrar with your documents, death certificate, birth certificate, ID cards, and get letters of administration, then proceed to the bank and have the monies withdrawn to do what you're supposed to do for your family. And it can be up to 40. Just imagine, Mr. Speaker, before it was $5,000 and less. Now it is $40,000 and less. So I want to thank the Prime Minister for providing further support to the vulnerable population as we move forward in terms of doing our best for poor people. Thank you very much, Mr. Speaker.
Member for Suzel Saltibus.
Thank you, Mr. Speaker. Mr. Speaker, I rise in support of the Administration of Small Successions Bill. Mr. Speaker, you have been around long enough to appreciate some of the things, as the member for Castries East indicated, the number of things that constituents believe that you have the power to do. And on many occasions I've had to only indicate that all I can do is to write a letter as far as it relates to my intimate knowledge of the individual to assist them in going a little further. But Mr. Speaker, I want to speak to the increase from $5,000 to $40,000. At one time, I'm sure the lawmakers felt that $5,000 was a reasonable amount to have as an upper limit. And as time evolves and wealth grows and things progress, people see the need to, the wisdom as it is now, Mr. Speaker, and I'm sure with the number of requests coming to the attention of the powers that be, they saw it wise to adjust the amount from $5,000 to $40,000. So I am full support of the adjustment, Mr. Speaker. I believe the member for Castries South East raised a number of issues as far as it relates to assets, which in my mind might involve a bigger legal debate, of which I may not be qualified to do, but I think that's for another discussion altogether, Mr. Speaker. But as far as this is concerned, I am in full support, and I believe it will help with the number of inquiries and some of the difficulties that people face when members of their families pass. So I thank you, Mr. Speaker.
Member for Castries Central.
Mr. Speaker, I stand in support wholly and solely of this bill, this Amendment Act today. And I can tell you, Mr. Speaker, from the standpoint of being a lawyer, and I want to speak inclusively here, the bigger the administration sum was, the value of the estate, the wider the green would be on the lawyer's face, because invariably he or she would charge more money the larger the estate is valued at. But Mr. Speaker, for a very, very long time, those persons who unfortunately find themselves at the lower end of the financial spectrum encountered much difficulty, because first and foremost, there was no provision for the registrar to have intervened and to have executed letters of administration. So the first step, Mr. Speaker, was to ensure that at least where the estate is worth no more than $5,000, then the registrar can intervene to avert the expenditure by the successors of such a small sum. So it is embracing, heartening, and of course, Mr. Speaker, it appeals to the consciences of good men and women to understand what Maliways go through. Mr. Speaker, if you address your mind to the situation one would have lived for the entirety of his estate when he meets his demise and goes to see the maker, for his entire estate to be valued at $5,000, we must admit he was a pauper. He would have had to be a pauper. And for those persons who are inheriting that little bit of inheritance to face a lawyer, Mr. Speaker, that in itself was unconscionable. But some lawyers, you know, they don't care. I mean, they're there to make their money, and that's what it is. Some are conscionable. But, Mr. Speaker, I'm glad we are putting this in place. I have one reservation. I do believe, Mr. Speaker, in this climate of escalating prices, where values of property rise astronomically, I do believe that even $40,000 is insufficient. You will not find 4,000 square feet of land located anywhere unless somebody close to you decides, I will give it to you, residential that is, for $40,000. Probably agricultural, but if it's agricultural, it will not be divided into small lots of 4,000 square feet. So, Mr. Speaker, putting that in perspective, it is my view, my humble view, and I will at committee stage to ask this Honorable House, Mr. Speaker, to augment that 40,000 to 50,000. I do believe we can do that, Mr. Speaker, so that at least we provide greater latitude for those persons who are inheriting what is not a lot of when the entirety of your estate is $40,000, Mr. Speaker. Hear this well. You can't get a used vehicle for $40,000. You cannot get a good used vehicle for $40,000. It has to be a 2002 model. It has to be some motor car that has been beaten down. So we have to be realistic. So in that regard, there's an old saying, the maxim is whatever is worth doing, Mr. Speaker, is worth doing well. So in that regard, taking cognizance of prices of everything, and I referenced the car. What car can you get? So a man dies, living as his sole asset, a car valued at $45,000. He goes to the lawyer to get the transfer done. The lawyer charges $5,000, $6,000, $7,000. Invariably, the asset has to absorb the value of the execution or administration of the estate. And if that's all he left behind, it then means the value of the car is augmented, not meritoriously, not by doing any work on it, but by the mere fact that there was a fee to be paid for transition to the owner who will now be entitled to sell it. So I do believe, Mr. Speaker, we can augment that. And I have absolutely no difficulties. It will bring relief. It will bring a lot of relief to a number of people in this country. And I could tell you, Mr. Speaker, when this bill is finally passed, a lot of St. Lucians, a lot of poorer people will be saying hooray for the government because they have done something to at least recognize that there is no need for the invocation of any kind of legal representative insofar as administering such a small estate is concerned. Mr. Speaker, I look at this futuristically, and sometimes, you know, when law is passed, it must not be passed with myopia. You have to look down the line. I am not sure. I know it was in the former bill, Mr. Speaker, but the gazetting, or rather the minister being empowered to do evaluation of the property, that in my mind, Mr. Speaker, because Mr. Speaker, let's face it, and I remember, Mr. Speaker, I remember being part of a former administration, and I'm saying this, Mr. Speaker, to reference that situation, being part of an administration holding a meeting at Coco Palm for us to discuss the acquisition of the Dahe Mall. And Mr. Speaker, you had some people sitting around the table who did not own a square foot of land, but were making a real estate decision on behalf of the entire country. That's the irony of it. So You don't own a car, you don't know how to drive, but you want to teach somebody to drive. That's the irony of it, Mr. Speaker. So I'm not sure, Mr. Speaker, with longevity and with the lack of myopia, that we necessarily want a minister, because that minister can be anybody. That minister can be anybody who is now empowered to do valuations. Probably if it was the member for Castries Southeast, who is realistically endowed with the skill set to do so, I would have had no difficulty.
Remember, you're dealing with a part of the substantive act that is not dealt with in the amendment.
Yeah, it's dealt with, Mr. Speaker.
Where?
On the 5, Section 3 of the Act is also amended to give the power to amend the value of the movable or immovable property comprising the testamentary succession or the intestate succession of a deceased person by an order published in the Gazette.
Section 5
Yes, Mr. Speaker.
of the amendment before us?
Yes, Mr. Speaker. Point 5, sorry, Mr. Speaker. Point 5.
I'm a little lost.
On the first page, point 5. Yeah.
Well, I see what what 5 says. I don't see that reflected in Section 3. If you're going on the explanatory notes, I'm guided
5 to 40. Okay, well, yeah, but it still says under C, Mr. Speaker, notwithstanding subsection 1, the minister may by order in the Gazette amend the value under subsection 1. Yes,
That's
Mr.
a different
Speaker,
thing.
I agree with you. Point taken, Mr. Speaker. But one's ability or the prerogative being given to amend the value, if you have to take it from the initial standpoint, is really affecting your own valuation. Because if I am empowered to amend the value given by a quantity surveyor, I'm in effect.
No, member, that's not what that is saying.
That's not
this
what
is saying the minister has the ability
Yes.
to move the value allowable from 5 to 40,000. He also has the ability to move it from 40 to 50, not to value the property.
Very well. Very well. Very well. Well, in that regard, Mr. Speaker, I stand corrected. There was some misreading on my part because I really thought my colleagues are saying that's how they read it. That's how I read it. That's how I read it. That notwithstanding subsection 1, the minister by order in the amend the value under subsection 1.
So it simply means if
that
the
he has
minister,
the authority to move from 40 to 30
without
to
coming
50.
back here,
Very well.
without coming back here, you can
Very
simply
well,
gazette it.
I stand corrected, and it is a welcome amendment, Mr. Speaker, because I do believe that law is dynamic and should never be static. And as we move on, Mr. Speaker, one needs to have the ability to deal with situations as they unfold, increase prices, and everything else. So in that regard, Mr. Speaker, this is a welcome bill. I embrace it, and I am indeed happy for the thousands and thousands of St. Lucians who will no longer have to pay legal fees in ensuring that the small estate of their parents is done by way of letters of administration. But still, Mr. Speaker, at the committee, stage, I will suggest that we move from 40 to 50,000, notwithstanding the powers of the minister. I thank you, Mr. Speaker. I support the bill.
Member of Soufriere Forsyth.
Thank you, Mr. Speaker. Mr. Speaker, I'll be extremely brief, but I feel it is very important for me as a member of parliament, especially for the constituency or sous frère Franche Jacques, to stand in support of the administration of small succession amendment bill presented here today. Based on my own experience and knowledge of what has happened, where persons have inherited, and because of families not having the funds to go to lawyers, a lot of inheritance and estates remain undivided. And instead of persons having the ability to have subdivisions of whatever is left by their parents, so that children could inherit, they could go to the bank, get mortgages, get education. This is something that has affected a lot of people. And today I stand on behalf of my constituents to say thank you to the Prime Minister, thank you to the government for this particular move. Aujourd'hui, qu'on nous concite et puis nous parler à sous loi nous about pour faire côté nous tenir loi côté les amouni en famille qui était en propriétaire bayo si propriétaire ça là c'était $5,000 et bien plus passer $5,000 ou tenir pour aller au un avocat pour garder pour papier ou tenir pour aller à l'audience au juge. À présent, le gouvernement a décidé pour tirer $5,000 et mener pour $40,000. Ça manque c'est un bon bagage et puis qu'il essaie de donner chance les familles qui tiennent un bagage puis ça joindre plus aisé. So, bon matin là, après-midi, moi je veux dire merci pour le Premier ministre là, merci pour le gouvernement pour prendre action ça là, parce que ça c'est une action qui bénéficie Malawi simplicity. Thank you, Mr. Speaker, and I support the amendment before us.
Member for Castries North.
Mr. Speaker, it isn't my intention to regurgitate what has been said previously, but merely to support the Prime Minister, member for Castries East, on having presented this very significant amendment to the legislation. And to say that there is one particular issue, and I hope the AG will be able to address it, and because there is a situation, Mr. Speaker, when it comes to movable assets, and one of those movable assets being a motor car, as mentioned by the parliamentary representative for Castries Central. Upon the death of, say, a husband or a wife, who is left probably with little or no, really not much of assets in value. And what is left behind sometimes, it's a car, maybe a taxi. And to proceed with insurance and registration and licensing, the difficulty is that unless that probate of will or the succession is done, that individual's hands is tied. And in many instances at the Transport Department, there are people who come and plead, please, I need to sell this car so as to settle all other debts owed by the estate. And according to the law, they are not allowed, they are barred. And I've been given explanations already, Mr. Speaker, in terms of, who are the successors, etc., etc. Is it just the wife? If that individual probably have, as we call it, illegitimate children, what if somebody emerges and says, listen, I have an interest in that car? They are not allowed to do anything. And invariably, Mr. Speaker, what happens, that car remains there, sometimes it rots away, and that individual is left with a vehicle, a derelict vehicle, after 5, 6, 7 years of not being able to raise the necessary resources, unable to sell it, so as to attend to the residual challenges and debt, etc., within the family. So I'm hoping that at least somewhere along the line, the Attorney General can answer my question. Would that lacuna be dealt with? Will that lacuna be dealt with, Mr. Speaker, as a consequence of this amendment of administration of small acts is concerned? Thank you very much. What's that? What, 24? Oh, great. Give it to me. Thank you. Good.
Minister for Justice.
Thank you, Mr. Speaker. Mr. Speaker, you heard for yourself from the contributions by honorable members what that amendment means to the people they represent, Mr. Speaker. And I have nothing more to say but to ask us to move on and thank them for their support.
Honorable members, the question is that the Administration of Small Successions Amendment Bill be read a second time. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Administration of Small Successions Act, Cap 4.12.
Clause 2.
Amendment of Section 2.
Clause 2 stands part of the bill. Clause
Mr.
1.
Chair.
Clause
Mr. Chair.
Clause 3.
Pardon?
Mr. Clause 3.
Oh. Clause 3.
There's clause 3.
You had a question on 2?
Yeah.
Yes, I raised the issue, Mr. Chair, and asked whether the Attorney General would be able to guide me.
Clause 2 is simply correcting the alphabetical sequence. Eh?
No, I'm not questioning that, Mr. Chair.
No, you're making an intervention on clause 2.
No, not clause 2. Clause 2 is okay. Before you go to clause 1, I'm asking a question based on my presentation, whether the AG would wish to guide us on the matter which I raised pertaining to persons who have died and left behind a motor car, for example, and really want to dispose of it within the shortest possible time to address issues pertaining to the estate. And if it means getting another section in or returning here, I just need some guidance.
Yes. Okay, well, this, honorable member, this section will address some of the issues. In terms of it is one person who has, who's basically entitled to the car, one person, but sometimes you mention there are a number of people who may be entitled. So this section will not address it. It may address up to a particular value if the car is about 40,000 and less. That's one particular section. But in terms of the other inheritance issues, the section would not address it. So we could look at it, discuss it, and if we have to amend it, then we can do so. But it may address one particular issue. Correct.
Thank you.
Thank you, honorable member.
Clause 3.
Amendment of Section 3.
Mr. Chair, that is why I was asking the AG, Prime Minister, whether we are minded, although the Minister has the authority to gazette and to increase the succession, the amount of the succession, I'm proposing at this committee stage that we increase it to 50,000.
He is proposing an increase to 50,000.
It's a matter for honorable members. It's a matter for honorable members.
Honourable members, the question is that the number 40,000 be increased to 50,000. And now put the question, as many as have that opinion. You want to say something? 200,000. Are you on the record for the 200,000? Well, yeah, and we have to vote on each number, so. Okay.
No, but the question is why 50? And I think that's the point he was making, because it can always be raised. So why 50 and not 60?
No, I'm saying 50, given the fact that the average, and I look at it not with myopia, like I said, the average vehicle is more than that, and it may form the sole asset of the estate. And to administer that succession, you will invariably be increasing the price of the vehicle without doing any work on there. So I'm just rounding it up to 50. 50 is half of 100. The minister has the authority to further gazette for the increase. So we can just leave it at 50. We can ask why 40. But to me, 50 is more comfortable and more well-rounded.
So, Member for Switzerland.
Yeah, the question I want is, the current figure that is inserted here, 40, was that through cabinet or through advice from the legal fraternity? Yes.
It was after discussion. It was a reasonable figure at 40,000. So if members want to like to consider moving it to 50, it's a matter for members to deal with.
Members, the question is that 40,000 be expunged and replaced by 50,000. And now put the question. As many as have an opinion say aye. Aye. As many as have a contrary opinion say no. I think the ayes have it. The ayes have it. So 50 it is. AG, if I may be permitted, I need to ask you, is it correct to say deleting the words when we deliver a figure, or delete the amount of? Yeah. So members, the proposal is that where it says deleting the words, that the word would be removed and replaced by amount of. And I'll put a question. As many as that view say aye. As many as have a contrary view say no. I think the ayes have it. The ayes have it. Clause 3 as amended stands part of the bill. Clause 1.
Short title.
Okay, the AG would like one moment. I think the AG would like to address us on the question of the word words.
I'd like to, with your permission, Honourable Speaker, keep the words in. I think under the interpretation, interpret it that way. The words mean numbers, so let's keep the words.
Fair enough.
As so. Okay. Thank you.
So that
yes, the words, yes.
Rather than changing it to amount of, we keep the original word
construct
and words.
Words, correct. Thank you.
Okay, clause 3, as amended, stands part of the bill.
Still under clause 3, Mr. Chair. And it wasn't up to me alone. I mean, the subsection 1A, 3C1A, notwithstanding subsection 1, the minister may, by order published in the Gazette, amend the value under subsection 1. My colleagues had the same difficulty that I did. This does not lend to unequivocality. In other words, it can be construed in two different ways. I'm not sure if we could use words here to basically to confine it to the total value of the estate.
But should we not be referring to what section 1 says in the substantive act?
I don't have the substantive act.
Because if it's going to amend, it's going to say amend the value under subsection 1.
Right.
You would need to know
what subsection 1 says. You have it?
AG is not the value. He is interpreted to mean AG, he is interpreting this to mean the minister can amend the valuation. But that's not what it means. There's a difference between valuation and value.
You said so, Mr. Speaker, but I'm saying that, you know, that the misinterpretation didn't confine itself to me alone. My other colleagues thought the same. And so I'm saying that I don't know what subsection 1 says.
Subsection 1,
Yes.
if I may, subsection 1 speaks to the value, the sum of $5,000, and that's what we
That's
amend.
what I'm saying. As opposed to what you're referring to,
in terms of the
which is a valuation.
The value,
different things.
5,000.
Very well. Very well.
Thank you. Thank you,
Very
Mr. Speaker.
I'll send the invoice. So, clause 3, as amended, stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honourable members, I beg to report that the administration of Small Successions Amendment Bill went through committee stage with amendment to Clause 3. Minister for Justice.
Mr. Speaker, I move that the report of the committee be adopted and the bill be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the administration of Small Successions Amendment Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Administration of Small Successions Amendment Act 2025.
Minister for Finance. Pardon? But we have the Banking Act. Okay. Minister in the Office of the Prime Minister of Responsibility for Home Affairs.
Mr. Speaker, I beg to present for first reading a bill shortly entitled Immigration Amendment.
Immigration Amendment.
Mr. Speaker, I beg to move for the suspension of Standing Order number 48-2 to enable the bill to go through its remaining stages at this sitting.
Honourable members, the question is that Standing Order 48-2 be suspended to allow the Minister for Home Affairs to proceed to the remaining stages of this bill at this sitting. And now put the question, as many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. Ayes have it. Leave is granted. Please proceed, Minister.
Mr. Speaker, the amendment before us is simple and straightforward, but it is also a very necessary amendment to the Immigration Act. And what this amendment intends to do is to delete the current definition of minister in the Act and replace it with the following: minister, which means minister with responsibility for immigration matters. And Mr. Speaker, whilst this may seem as a very minor change, it is critical for ensuring clarity and administrative efficiency. Traditionally, immigration matters have fallen under the remit of the Minister for Home Affairs. And as such, the existing definition of minister in the Act reads as a minister whom the subject of Home Affairs has been assigned. However, in our current configuration, our current government structure, the portfolios of Home Affairs and National Security are no longer held by the same minister. So the Department of Immigration remains a branch of the Royal St. Lucia Police Force, which falls under the umbrella of the Ministry of National Security. And this separation, Mr. Speaker, has created a level of ambiguity in interpreting the responsibilities outlined in the legislation. So this amendment tends to remove this ambiguity by clearly stating that the minister referenced in the Act is the one specifically responsible for immigration matters, regardless of which ministry it falls under. Mr. Speaker, this is, again, a very small legislative adjustment, but one that brings necessary clarity and better aligns the Act with the current administrative structure of the government. So, with this said, Mr. Speaker, I'd like to encourage members to support this amendment.
Mr. Minister, my understanding that you just moved the bill to expunge the Prime Minister from a position? Honorable members, the question is that the Immigration Amendment Bill be read a second time. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Immigration Act, Cap 10.01.
Clause 2.
Amendment of Section 2.
Clause 2 stands part of the bill. Aye. Clause 1.
Short title.
Clause 1 stands part of the bill. Aye. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honourable members, I beg to report that the Immigration Amendment Bill went through committee stage without amendments. Minister responsible for immigration.
Mr. Speaker, I move that the report of the committee be adopted and that the bill be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the Immigration Amendment Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. Ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Immigration Amendment Act 2025.
Minister for Home Affairs.
Mr. Speaker, I beg to present for first reading a bill shortly entitled Passport Amendment.
Passport Amendment.
Mr. Speaker, I beg to move for suspension of Standing Order number 48-2 to enable the bill to go through its remaining stages at this sitting.
Honourable members, the question is that Standing Order 48-2 be suspended in order to allow the minister to proceed with this bill for all of the remaining stages at this sitting. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Leave granted. Please proceed, Minister.
Mr. Speaker, again, similar to what we witnessed a while ago, this amendment is just again to align to get the corresponding minister. Since we've changed ministries, the Ministry of Home Affairs and National Security are no longer under the same minister, so this amendment would allow the Prime Minister, who now has the responsibility, or always had the responsibility, Mr. Speaker, for national security, to be able to take action in matters relating to passport, because there was, again, the act under the act, it gave the responsibility to the Minister of Home Affairs, and we realized that there is, as the member for Castries South would have said, a lacuna in the legislation. So this is just to align it and to allow, for Castries North, sorry, to align the responsibility with the designated minister. So again, very simple but very timely, very important amendment, and we just encourage members to support this amendment.
Honourable members, the question is that the Passport Amendment Bill be read a second time. I now put the question. As many as of that opinion say aye. As many who as a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Passport Act, Cap 10.03.
Clause 2.
Amendment of Section 2.
Clause 2 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. The ayes have it. The ayes have it. Honourable members, I beg to report that the Passport Amendment Bill went to committee stage without amendments. Minister for Home Affairs.
Mr. Speaker, I move that the report of the committee be adopted and that the bill be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the Passport Amendment Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Passport Amendment Act 2025.
Minister for Finance. Your microphone.
For second reading, a bill shortly entitled Banking Amendment. Mr. Speaker, this bill, Mr. Speaker, is another in a series of regional legislation being proposed by the Eastern Caribbean Central Bank. As you know, they are the monetary authority for the Eastern Caribbean Currency Union, Mr. Speaker. The islands of the OECS share a common currency, which in effect, Mr. Speaker, is one of the strongest currencies in the world, the Eastern Caribbean dollar. And this is because of the strength of the ECCU, the Eastern Caribbean Currency Union. And you may note that the EC dollar is pegged to the US dollar. And for many years, for decades, Mr. Speaker, it has been $1 US is worth 2.7169 or thereabout EC dollars. That has caused stability in our trading systems, in our trading patterns, Mr. Speaker, confidence in the EC dollar, and because of the fact that there is an Eastern Caribbean Currency Union, the EC dollar has remained a very solid mode of exchange, Mr. Speaker, and an institution that we can be very proud of as members of the OECS, Mr. Speaker. And that speaks a lot to the value of economic integration. It speaks to the value of the fact that as a region, unity is strength, Mr. Speaker. And there can be no other institution that can speak more to the value of integration and the value of even sometimes you relinquish some of your sovereign authority and put it under the umbrella of a regional institution, how beneficial that can be. So, Mr. Speaker, the foreign exchange problems that some of our neighbors have, albeit they larger than us, thankfully, we do not have these issues in the OECS, Mr. Speaker. So it's a very fulfilling feeling, and all Ministers of Finance will tell you that the confidence that they have in the EC dollar and how our EC dollar is recognized and our EC dollar is used as an example of what stability in the currency should be, Mr. Speaker. But from time to time, as the system changes, as the financial infrastructure changes, there is need to modify laws and need to modify bills, Mr. Speaker. And the Eastern Caribbean Central Bank has seen it possible or necessary to amend the 2015 Banking Amendment, 2015 Act, Mr. Speaker, to amend the 2015 Act, Mr. Speaker. And that amendment is, we want to amend the 2015 Act, Mr. Speaker. And that amendment, we are asking members to support. The amendment, Mr. Speaker, is basically to clarify the definitions. It's basically to clarify certain definitions, Mr. Speaker, to ensure clarity of intent and consistency in language, Mr. Speaker. The definitions that the amendment seek to change, Mr. Speaker, or to strengthen, Mr. Speaker, are in Section 2 of the Act, Mr. Speaker. These amendments are as follows. Definitions of an affiliate, to clarify an affiliate, the activities that constitute banking business, the definitions of exposure and large exposure in the conduct of prudential and supervisory activities, the definition of a financial group and a licensed financial holding company, and the definition of an officer, Mr. Speaker. It seeks to clarify what that means, Mr. Speaker. It also seeks to create clarity on the definition of a domestic bank and a foreign bank. And this was amended to classify banks originating from within CARICOM but outside the ECCU as domestic banks, consistent with the revised Treaty of Chaguaramas, Mr. Speaker. Mr. Speaker, the definition of a branch is introduced to bring clarity and to distinguish between a branch where all banking business can be transacted and a bureau de change, which focuses on purchase and sale of foreign currency, Mr. Speaker. So a bank's branch is where all business activities can be processed. But the bureau de change is where you only change currency. So the Act gives clarity as to what's a branch and what's a bureau de change, Mr. Speaker. Mr. Speaker, it also makes provision certain policy issues, Mr. Speaker, to be addressed by the Amendment Act of 2018, Mr. Speaker. And these issues have arisen during the implementation processes and they require policy adjustments. The following key issues, Mr. Speaker, have been the subject of that change. The Banking Act 2015 imposes limitations on certain activities of banks, including the prohibition on declaring or distributing dividends during any financial year that the licensed financial institution experiences a loss, Mr. Speaker. And Mr. Speaker, this is significant because a bank should not be paying dividends if they have a loss. If you're supposed to pay profits, pay out of profits, Mr. Speaker. So if you have a loss, you should not be paying any dividends, Mr. Speaker, because what you're doing is the depositors are the ones who are paying and not the profit that you make from the bank. So it prohibits that, Mr. Speaker. It also gives restrictions on investments in real estate and restrictions on unsecured lending to employees to 50% of the annual remuneration of the employee, Mr. Speaker. To unsecured lending to employees, Mr. Speaker. The amendment confers the discretion on the bank to grant approval to financial institutions to activities referenced above and to lend unsecured employees up to 100% of the employee's remuneration. And again, Mr. Speaker, this is a necessary change under the circumstances, Mr. Speaker, particularly the one that says that you cannot pay dividends if you're having a loss. Mr. Speaker, the other amendments relate to audits and information, Mr. Speaker. As far as audit and information is concerned, Mr. Speaker, the current provisions require financial institutions to change the external auditors every 6 years and the lead concurrent partner every 3 years. Mr. Speaker, every audit assignment, there is a lead partner. So when the audit is being performed, the one people in the auditing firm, one partner is the lead partner. So all the files have to go to him, Mr. Speaker, for his approval, etc., before his approval, his agreement, he or she, before the file is presented and the financial statements are sent to the directors to approve. In the old Act, Mr. Speaker, auditors had to be changed every 6 years. An auditor could not be appointed if he was in the business, if he was auditing the firm, auditing the bank for 6 years or more. That has been amended, Mr. Speaker, to 9 years because of the fact that the business of auditing has become very complicated, Mr. Speaker. sometimes, to my mind, too complicated, but it has become very complicated, and it is not easy to get audit firms who have the capacity, who have the knowledge, who have the expertise, who have the staff to audit institutions like commercial banks or financial institutions, because the international auditing standards change all the time. You have to have new criteria. The standards are changing. So to get firms, audit firms, who have the capacity and the capability to audit large banks, etc., is the pool is becoming smaller and smaller, becoming smaller and smaller. And because of the liability involved in auditing, sometimes you find that audit firms sometimes don't want to get involved, don't want that level of exposure. So the Act seeks to amend 6 years to 9 years. So an audit firm can remain auditing a particular bank for 9 years instead of 6 years, Mr. Speaker. And also says that the lead partner must be changed every 3 years. So even the firm maintains the audit, the partner who is in charge of the audit, Mr. Speaker, must change, Mr. Speaker. It also deals, Mr. Speaker, with, so you have to change the auditor every, you have to change the auditor, the director, Mr. Speaker, every 3 years. The managing partner every 3 years, Mr. Speaker, and the external auditor every 9 years instead of every 6 years, as in the present Act, Mr. Speaker. Mr. Speaker, it also speaks to directors, Mr. Speaker, and it says that they want to, so we changed it, Mr. Speaker, from 9 years, the firm every 9 years, and the partner every 6 years. Right now, the partner is every 3 years. So the firm can remain for 9 years, but the partner who is in charge of the audit can be changed every 6 years instead of every 3 years, Mr. Speaker. Mr. Speaker, finally, the changes in the paid-up capital for foreign banks and the treatment of discharged bankrupt persons appointed to serve as directors, 7 years, a 7-year term frame was included. This means, Mr. Speaker, that for you to be able to be a director in a bank, if you cannot serve, Mr. Speaker, if you're a bankrupt person. The treatment of discharged bankrupt persons appointed to serve as directors, a 7-year term frame was included, Mr. Speaker. So you have to be you have to not be bankrupt for 7 years, Mr. Speaker, if you want to be a director of a bank. There's also introduction of an appeals process for persons aggrieved by decisions of the bank, Mr. Speaker, under the fit and proper provisions. So if you are aggrieved by a bank's decision, you can appeal that decision, and there's a process in which that appeal is held, Mr. Speaker. And it also prohibits the institution of shell banks and provides guidance to the outsourcing of services and investments, Mr. Speaker. Again, necessary to protect the consumer, to protect the depositor, Mr. Speaker. So when somebody puts their money in a bank, they can ensure that they can get their money back when they need it, Mr. Speaker. And this is very important. So for the confidence and the stability of the financial system, and the confidence and stability of the consumer when he places his savings in a bank, Mr. Speaker. Because you've heard about the collapse of banks, Mr. Speaker. So this act ensures that certain guidelines are put in place to protect the consumer, Mr. Speaker. But having said so, Mr. Speaker, the consumer must always understand that they have the last say. The money belongs to them. Sometimes we don't understand that the money in the bank belongs to the depositors. and depositors always have the last say, Mr. Speaker. So depositors must literally watch their business, literally mind their business, Mr. Speaker, and ask questions, demand questions from banks. And banks also must understand that the money they hold, the money that they hold for depositors, they hold the money in their custody, but it's for the depositors. And they must be prepared to answer the necessary questions and give the relevant information, Mr. Speaker, to consumers. And having said so, Mr. Speaker, sometimes it is very heartbreaking when particularly elderly people who do not have the facilities, who don't have, sometimes are very literate, Mr. Speaker, when they want to have a transaction from a bank, Mr. Speaker, they are asked so many questions. They are asked to open accounts. They are asked to have cards, Mr. Speaker. And I think something must be done where people, particularly elderly people, who do not have the necessary wherewithal, Mr. Speaker, to allow them to take their money when they want it. And we had to make some adjustments in the government system, Mr. Speaker, when the Treasury was demanding that checks be written to people, that people had to have a bank account, even though these people had a fire at their home, and everything got burned, Mr. Speaker. So whereas we need transparency, we need accountability, we must never have processes and procedures that would eliminate people from achieving what they want, Mr. Speaker. We must adapt the processes that we have so everyone can access it, by the same time allowing for full transparency and accountability, Mr. Speaker. So I urge members to support the amendment, but I also urge the banks to change in some ways in which they treat their customers and to be a little more flexible. I know we're going to have legislation coming very shortly for the opening of bank accounts. That legislation is, and I want to thank the central bank for ensuring that that legislation comes to being very shortly for us to change the way, the difficulty that people have in setting up bank accounts. That will come to a stop, to an end very shortly, Mr. Speaker. The central bank has always been mandated to cause the commercial banks to stop this thing about 3 ID cards and use your father or use your godfather to open a bank account, Mr. Speaker. And I'm glad that that will change, if it hasn't changed, very soon, Mr. Speaker. So, Mr. Speaker, we support the amendment, but we also want to tell the banks that they must sometimes exercise some restraint in the powers that they have. I understand that the customer is boss, and they must be more flexible, and they must, when somebody wants to access a banking service, it must be made easier for them, particularly the elderly and the people who are not exposed to cards and debit cards, etc., etc., Mr. Speaker. We have to find a way to make life easier for them. Again, Mr. Speaker, final thing I want to see is on disclosure requirements, Mr. Speaker. And I know my friend the Attorney General and the members of Cabinet always speak to him about something called NAMLOC. Where, Mr. Speaker, where people in the tourism industry who go to the bank with a few US dollars are asked all kind of questions, Mr. Speaker, about where they got it from and what they did for it, Mr. Speaker. Mr. Speaker, you know, and they put it under the excuse of money laundering. But, Mr. Speaker, I mean, it's rather strange for a taxi driver to go to the bank with $1,000 US, and you want him to ask, and he talk about insurance, all kind of fancy language, Mr. Speaker. I think that the bank, whereas they have to deal with disclosure, the bank must show a certain level of flexibility. There are certain countries in the region where US dollars are not only legal tender, but interchangeable. There are countries in the region where you pay in US dollars, they give you change in US dollars. But in St. Lucia, we seem to have a high level of I don't know what, that it makes it so difficult for people in the tourism industry to convert their US dollars into easy currency, Mr. Speaker. I don't think it's necessary. I think the compliance officers are over exuberant in these cases, Mr. Speaker, and I think that the banks have to be a little more flexible as it relates to dealing with ordinary people in this country, particularly in a country that you say that is a tourist destination, Mr. Speaker. So whilst I support the amendment, I support the strengthening of the regulations and the processes, I also support more flexibility and more give and take as far as bank transactions are concerned. I thank you, Mr. Speaker.
Honourable members, the question is that the Banking Amendment Bill be read a second time. Member for Susan Saltibus.
Thank you, Mr. Speaker. Mr. Speaker, the member for Vieux South is not here this afternoon, but I am almost pretty sure had he been here, he would have stood up on to make some comments on this bill, particularly, and he would speak about unscrupulous fees that the banks charge, Mr. Speaker. In fact, when the member was talking about certain activities of the bank, I was hoping that maybe I did not see it and there was something about the inclusion of a standardized format among the banks as it relates to the way fees are charged, Mr. Speaker, because we hear as parliamentarians the way you go when you go to banks and some of the charges that are charged, and different banks have different charges, and it's a very concerning matter that has been brought about from our constituents. So I was very happy to hear from the ECCB that there's discussion with regards to the opening of accounts and that you no longer require several pieces of ID. And in fact, I heard the central bank governor speaking recently on a program also asking people to submit their views and opinions as to how they can make their banking experience a lot more comfortable. So I'm hoping at the same time when we will get this new legislation with regards to the opening of bank accounts, we could see some form of uniformity as it relates to how banks apply charges for various aspects of having accounts with them, Mr. Speaker. But the member for Castries East, the Prime Minister is very correct that as the world is evolving, things need to change. Particularly, we have a world where technology is growing as fast as we ourselves are growing, Mr. Speaker, and so things have to be adapted with the times. And so, Mr. Speaker, I understand and welcome some of the adjustments, but I do wish that there will be a little bit more personalized attention paid to how the consumers, as the member said, the depositors who actually are the kings, when it comes to the banking portfolio, how they are treated and how they going forward, the bank will ensure that they do not continue to, make the kind of profits they make on these fees that they do with the normal consumer. That being said, Mr. Speaker, I support the bill.
Member for Castries Central.
Yes, Mr. Speaker, very, very briefly. I heard the member for Swizzle Saltibus talking about he hopes the banks does not make the kind of profits that they make on poor people. I'm hoping his former employer is not listening to him so that when the time comes and he knocks on that door, because apparently he facilitated the entrepreneurship of the banks and facilitated and shared rather in the profit making. But Mr. Speaker, I want to say one thing on this. and the Prime Minister, in a kind of a surreptitious way, alluded to it. There is this term, PEP, politically exposed person. Prime Minister indicated that sometimes a little hustler outside the hotels selling T-shirts, selling shells, selling whatever it is to earn a legitimate dollar would go to the bank and is put through all sorts of convoluted procedures to ensure that his money is accepted and placed in the bank. Mr. Speaker, every politician, every one of us, have some relative of us that don't like us and we don't talk to them. Every politician. Yet, those persons are considered PEPs. In other words, those persons are put through rigorous due diligence, even if the person in the political arena is distant from them insofar as having a good relationship is concerned. And sometimes, Mr. Speaker, even you as a politician, you have legitimate sources of income. Not too long ago I had to tell a given bank, how can you lend a man money? Hear this well, Mr. Speaker. You lend a man money, his installment is X amount per month. The first thing you do as a bank is to assess his ability to repay. Yet when he repays, he has to pull in a source of funds. That is, I don't understand it. I really don't understand it, Mr. Speaker. Because if you're giving me a loan of $4 million, I need to pay $25,000 a month. I come to pay my $25,000, and every time I come to pay the installment, you want a source of funds. Whereas, you'd have had to determine my ability to repay from the onset. So there are loads of difficulties, Mr. Speaker, which this bill cannot speak to in their entirety insofar as what pervades the banking sector. We go through difficulties, Mr. Speaker, as politicians. Our relatives from far and wide. Do you know Stephenson King? Yes, I do. And I'm using his name now because that's the question they will be asked. What is it to you? He's married to my cousin's sister. You are PEP. Yes. You are PEP. You are politically exposed person, Mr. Speaker. And with due immediacy, they unravel difficulty on you as though you are on a wanted list, Mr. Speaker. I don't know how they do it. In fact, Mr. Speaker, we've passed legislation in this honorable house where you can deposit up to 10,000 US. Not so, Mr. AG? 10,000 US. Yet somebody goes with much less than the amount, Mr. Speaker. Much less. And they are put through difficulty. So the question is, are the laws on the books for show? Are the laws on the books for show? Can the banks decide unilaterally to set aside the legal principles and the law by which we all should abide and say, look, notwithstanding the law says so and so, I want you to do so and so. So a man goes with 600 US, and because he's not a man who probably came from an economically sound family, because he's a man who hustles and keeps his dollars, he goes with 600 US, and all of a sudden, the bank is giving him extreme difficulty. So there are loads of problems, Mr. Speaker, but we have to deal with them one by one. We cannot fix everything at once. And that having been said, Mr. Speaker, I support the amendments. And I'm hoping that the day will come when politicians and their families are not put through this. That is not to say, Mr. Speaker, if somebody has ill-gotten gain, they should be facilitated. I'm not saying this. I am saying, Mr. Speaker, that the unnecessary hardship that politicians and their relatives are put through in a lot of instances, in fact, in most instances, are not justified. Having said that, Mr. Speaker, I support the amendment. Thank you.
Minister for Finance.
Thank you, Mr. Speaker. Mr. Speaker, there are a few things. There are a few things, Mr. Speaker, that the banking amendment bill dealt with, Mr. Speaker, which I did not go into much detail, Mr. Speaker. It deals with things like the limitations of a licensed financial institution to for including the maintenance of specified assets, section 55, Mr. Speaker. 57, the definition that was positioned under the provision for the maintenance of specified assets is repositioned in the Act as a new provision that provides a definition of specified assets. The new provision is section 43A, Mr. Speaker, includes as specified assets notes and coins which are legal tender in the currency union, and foreign notes and coins that the central bank may specify. Balances at the central bank and net balances at a licensed financial institution in the currency union, but while the balances are negative, they'll be subtracted from the specified assets, Mr. Speaker. Mr. Speaker, all the islands of ECCU, they have they maintain an account in the central bank. So that law says if you are in overdraft, it's subtracted. So you only show the net balance, Mr. Speaker. And I'm very pleased to tell you, Mr. Speaker, that St. Lucia always stays within its quota. There also provision for minimum paid up or signed capital, section 44. Section 44 is amended in the bill to change references to St. Lucia to the currency union and to insert a new provision that requires the central bank to approve the holding of assigned capital in the form of specified assets, Mr. Speaker. The bill also amends the provision in the Act on maintenance of the reserve fund, section 45, for a licensed financial institution or licensed holding company to obtain the written approval of the central bank if a declaration, credit payment, or dividend or other transfer from profits results in an impairment of the capital required under the Act, inadequate and inappropriate forms of liquidity, or negative return earnings or accumulated deficit. Again, Mr. Speaker, in an endeavor to protect the depositors, Mr. Speaker. Mr. Speaker, the bill amends the Act to remove references to capital base and substitute Tier 1 capital in the provisions in the Act relating to exposure, section 49, restrictions on exposure-related parties, section 50, and the prohibition of engaging or investing in trade and outsourcing, section 53. Submission of returns and production information as required by the central bank, section 89. Changes are made in the Act, in the bill, to the provisions on the restrictions on lending to employees, section 51. Acquisition and establishment of financial subsidiaries, section 54. Restrictions on investment in real property, section 55. And there are other provisions, Mr. Speaker, on the appointment of external auditors, which I dealt with, Mr. Speaker, before. There is amendments are made in the Act under the bill. For example, the provision in the Act that relates to the disclosure for the basis for charges, which the member for Suez spoke about. Section 92 is modified to state that a financial institution must make such disclosures to the central bank. It must say to the central bank on what basis they are charged, Mr. Speaker. Like when we have to give our statements to the Integrity Commission, they charge us money. Or if you want a statement from the bank, they charge you money. So in the new Act says, you have to see why you're charging, what's the basis of the charge, Mr. Speaker. And must make disclosures to the central bank, Mr. Alterations are also made in the bill to the provision in the Act that provide for the minimum criteria for determining whether a person is fit and proper. Section 97 and the disqualification of a director officer, Section 103. Capital increase to existing shareholders, Section 131, and termination of the Office of Administration, Mr. Speaker, Section 127. Grounds for receivership, Section 148. Commencement notice of receivership, Section 140. Avoidance of pre-receivership, Section 147. Report publication and disposal of abandoned property, Section 168. Secrecy of information, Section 178. And administrative policies to be placed to the credit of the central bank, Section 180. And repeal and savings, Section 192. All these are basically adjustments, Mr. Speaker, to these sections to make them more effective and give them more clarity, Mr. Speaker. Also, Mr. Speaker, there's a new provision to make provision for receivership and compulsory liquidation in respect of a person under Section 1381B. There's a new Section 138A, Mr. Speaker. And the schedule, Mr. Speaker, the Schedule 1 lists the fees for licensed financial institutions, also subsidiary in the bill, as well as Schedule 3 that considers the offenses of which liability to conviction may be discharged by payment of a fixed penalty, Mr. Speaker. So, Mr. Speaker, this bill really seeks to give clarity, and it seeks to deal with a resolution to an improved framework, Mr. Speaker, for the operation of banking in St. Lucia, Mr. Speaker. I thank you, Mr. Speaker.
Honourable members, the question is that the Banking Amendment Bill be read a second time. I now put the question. As many as of that opinion say aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
An act to amend the Banking Act, Cap 12.01.
Clause 2.
Interpretation.
Clause 2 stands part of the bill. Clause 3.
Amendment of Section 2.
Clause 3 stands part of the bill. Clause 4.
Amendment of Section 3.
Clause 4 stands part of the bill. Clause 5.
Amendment of Section 4.
Clause 5 stands part of the bill. Clause 6.
Substitution of Section 5.
Clause 6 stands part of the bill. Clause 7.
Amendment of Section 7.
Clause 7 stands part of the bill. Clause 8.
Amendment of Section 14.
Clause 8 stands part of the bill. Clause 9.
Amendment of Section 19.
Clause 9 stands part of the bill. Clause 10.
Amendment of Section 42.
Clause 10 stands part of the bill. Clause 11.
Amendment of Part 5.
Clause 11 stands part of the bill. Clause 12.
Amendment of Section 44.
Clause 12 stands part of the bill. Clause 13.
Amendment of Section 45.
Clause 13 stands part of the bill. Clause 14.
Amendment of Section 49.
Clause 14 stands part of the bill. Clause 15.
Amendment of Section 50.
Clause 15 stands part of the bill. Clause 16.
Amendment of Section 51.
Clause 16 stands part of the bill. Clause 17.
Amendment of Section 53.
Clause 17 stands part of the bill. Clause 18.
Amendment of Section 54.
Clause 18 stands part of the bill. Clause 19.
Amendment of Section 55.
Clause 19 stands part of the bill. Clause 20.
Amendment of Section 57.
Clause 20 stands part of the bill. Clause 21.
Amendment of Section 60.
Clause 21 stands part of the bill. Clause 22.
Amendment of Section 69.
Clause 22 stands part of the bill. Clause 23.
Substitution of Section 80.
Clause 23 stands part of the bill. Clause 24.
Substitution of Section 88.
Clause 24 stands part of the bill. Clause 25.
Amendment of Section 89.
Clause 25 stands part of the bill. Clause 26.
Amendment of Section 92.
Clause 26 stands part of the bill. Clause 27.
Amendment of Section 97.
Clause 27 stands part of the bill. Clause 28.
Substitution of Section 101.
Clause 28 stands part of the bill. Clause 29.
Amendment of Section 103.
Clause 29 stands part of the bill. Clause 30.
Substitution of Section 104.
Clause 30 stands part of the bill. Clause 31.
Substitution of Section 105.
Clause 31 stands part of the bill. Clause 32.
Amendment of Section 107.
Clause 32 stands part of the bill. Clause 33.
Amendment of Section 108.
Clause 33 stands part of the bill. Clause 34.
Substitution of Section 109.
Clause 34 stands part of the bill. Clause 35.
Amendment of Section 131.
Clause 35 stands part of the bill. Clause 36.
Amendment of Section 137.
Clause 36 stands part of the bill. Clause 37.
Amendment of Section 138.
Clause 37 stands part of the bill. Clause 38.
Insertion of new Section 138A.
Clause 38 stands part of the bill. Clause 39.
Amendment of Section 140.
Clause 39 stands part of the bill. Clause 40.
Amendment of Section 147.
Clause 40 stands part of the bill. Clause 41.
Amendment of Section 168.
Clause 41 stands part of the bill. Clause 42.
Substitution of Section 169.
Clause 42 stands part of the bill. Clause 43.
Substitution of Section 174.
Clause 43 stands part of the bill. Clause 44.
Amendment of Section 178.
Clause 44 stands part of the bill. Clause 45.
Amendment of Section 180.
Clause 45 stands part of the bill. Clause 46.
Substitution of Section 186.
Clause 46 stands part of the bill. Clause 47.
Amendment of Section 192.
Clause 47 stands part of the bill. Clause 48.
Schedule 1, fees for license, 48, yes, okay. Schedule 1, fees for licensed financial institution.
Pardon?
It's a substitution of Schedule 1, yes. And I read the...
Oh?
Yes, you go.
Clause 48 stands part of the bill. Clause 49.
Substitution of Schedule 3, offenses in respect of which liability to conviction may be discharged by payment of a fixed penalty.
Clause 49 stands part of the bill. Clause 1.
Short title.
Clause 1 stands part of the bill. It was very clear which members work out in this house. Honourable members, the question is that the committee rises and the bill be reported. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it. Honourable members, I beg to report that the Banking Amendment Bill went through committee stage without amendments. Minister for Finance. Your microphone.
I move that the report of the committee be adopted and the bill be passed, be read a third time and passed.
Honourable members, the question is that the report of the committee be adopted and that the Banking Amendment Bill be read a third time and passed. I now put the question. As many as of that opinion say aye. Aye. As many as of a contrary opinion say no. I think the ayes have it. The ayes have it.
Be it enacted by the King's Most Excellent Majesty, by and with the advice and consent of the House of Assembly and the Senate of St. Lucia, and by the authority of the same as follows. This act may be cited as the Banking Amendment Act 2025.
Leader of Government Business.
Mr. Speaker, I move that the House stands adjourned. Sine die.
Honourable members, the question is that this House do stand adjourned sine die. I now put the question. As many as of that opinion say aye. Aye. As many as of contrary opinion say no. Sitting adjourned.
We have come to the end, to the conclusion of today's sitting of the House of Assembly. Today we had a late start. Originally it was scheduled for 10 o'clock. That was moved to 12 noon, and later we started at approximately 1:30. This afternoon session, it was a short session where we saw the passage of two bills. There were a couple of bills that were deferred for a subsequent hearing. That is the Payment Systems and Services Bill, the CARICOM Arrest Warrant Treaty. There was a lot of discussion on the administration of small succession amendment, and most of the members made a contribution towards this bill. What this bill sought to do was to give the Registrar of the High Court the powers to issues like letters of transfer of property, movable and immovable property. In the case, if someone had left behind some property and after he was deceased, the amount really was around, say, 40,000, although the figure was moved to 50,000. Prior to this amendment of this bill, what the successors or the inheritors of the property would need to do was to have the expertise of a lawyer, who most times would be charging even more than what the estate of the deceased person was. So what this bill in effect did was to allow the Registrar of the High Court to basically take on the powers of a magistrate and issue those letters of transfer. So people who left behind property and who perhaps did not have a will, Michael, the registrar of the High Court now could decide to undertake, he would have the powers, this bill gives him the powers now to transfer the property into to the successors of those people who would inherit the property. Most of the members made a contribution. This was the most substantive bill for the afternoon. Most of the members made a contribution through the intervention of the housing minister. I think the original amount for deciding that was capped at 40,000, but the minister for the parliamentary representative for Castries Central, he made a suggestion to put it higher up to $50,000. And the Prime Minister felt this was a simple thing, but it was so significant because there are a lot of people who do not have large amounts of property, and on their passing, in the absence of a will, those who succeed in inheriting this are not even able to make any headway in that. And the other bill that was discussed and passed was the Immigration Amendment and the Passport Amendment. These two bills basically sought to just define the minister, okay, to read that or to mean that the minister would be responsible for immigration and the minister would be responsible for passport. It would, in other words, it defines the minister. And the reason why this bill became necessary or is necessary is because there are times, for instance, the Minister of Home Affairs, who would originally be responsible for immigration, that was the Prime Minister, but sometimes the immigration or passport decisions do not necessarily fall under the same minister, so it has to imply that the ministers would be responsible for this, Michael.
Very minor amendments.
Very minor amendments.
Avec mes ça qui était intéressé et puis de ces changements amendments là, nous avons créé changement. Si un petit morceau de loi pour en échanger petit bagaille avec un cas immigration et puis passeport. C'était la première fois on est là bon. Jeremiah Norbert, membre parlement pour notre micro, qui a présenté un amendement en loi. Et puis, il tenait un peu de confiance en présentation. Mais en l'autre, dernier ça qui nous passait là, c'était banking, ça c'est un autre amendement à ces affaires banques. Avec nous avons changé. Membre parlement pour soutenir force, c'est Dr. Kenny Anthony, Premier ministre temps passé, toujours qu'a dit qualité loi qui fait banque là capable c'est difficile et que qu'a fait trop difficile. Par exemple, même parlement pour meeting ville Castries honorable Richard Frederick, tu qu'a dit comme que si on prend un loan chaque année après il y a toujours voulu information même bagaille à commencement, so il y a fait difficile pour monde. Mais quand même le gouvernement fait amendement ça là, mais il a considéré, il a demandé pour considérer ces difficultés ça là qui en chaise mon expérience.
Definitely. So that banking amendment basically is just to small changes, hopefully to just improve the operations of the banking system. So there we have it. We've come to the end of today's sitting. We thank you so much for staying with us at the National Television Network. My name is Virgil Leonti on behalf of all of us here at the NTN, the technicians, and at the Government Information Service in general.
Moi, c'est Michael Gaspard, avec Virgil Leonti encore, nous avons merci un peu, avec nous ici encore mardi, si vous voulez, pour la session Sénat là.